Hello, Toolboxers. Welcome back. I'm immigration lawyer John Khosravi, and you're listening to Immigration Lawyers Toolbox podcast. I've been MIA missing for a couple months now, it seems. November was the last upload. I was surprised to see that. I thought it was not that far ago, but between the business taking its, my law firm taking its scaling, hiccups and growing pains and all that kind of stuff, how demanding it is, along with the holidays and something you might have all been experiencing, constantly getting colds and getting sick in the last 60 days. This is early February when I'm recording the intro for this. The recording is actually from months ago. Don't tell Kevin Gregg, I put it out now. We have a backlog of stuff have to go out, backlog of interviews, so we're trying to get them out now. But it's wild how everyone is getting sick. On the plus side, if you're sick at home and you're trying to learn immigration law, marriage immigration in particular, inadmissibility basics, consular processing, which I know a lot of immigration lawyers don't know because I constantly educating people and talking to them about it. We also have the adjustment of status, going by the statute, studying INA 245, the 212 statute. When we go through affidavit support, we actually go through the CFR and the stuff like that. Hardcore lawyering to be a great immigration lawyer on the marriage base, which is actually the family base and larger. Learning all that stuff. We have a course we did for it. It's really awesome. I'm really proud of it. So hit me up if you're interested in that. The Immigration Lawyers Toolbox Marriage Green Card course. Also want to thank our sponsor, Serenade. You all heard about them before. A lot of you have them already. They've been around for over 30 years or almost nearly 30 years. Probably when I wrote this is probably a little bit 30 years, but their modern practice management system, doing everything they can to be on the cutting edge. They even have AI coming and already in some of their software to help you analyze stuff like AO decisions and working on that. So it's really cool. They've been rewarded a bunch of stuff on Capterra. Most likely to recommend best support, best ease of use. It's trusted software for your team. It's worth mentioning. They got over 100 features. You pick and choose the ones you like. Very helpful and just a great staff and people I really care. I speak with the CEO of the company on a regular basis when I'm not constantly sick. He's just a stand-up person who really likes what he does. If you want more information about Serenade, visit their website, serenadewiththec.com, or best to email them at sales@serenade.com to do a demo, or their number 1-800-617-4202. I would recommend doing demos. Part of my New Year's resolution in 2024 is to contact tech companies and do demos, even if I don't want to do it. It's very time consuming, very annoying, but you learn so much about like what things are, and it helps you if I could compare too. But set that demo up and see what they have to offer and how it's going to help your law firm. I strongly recommend it. Having said that, let's get the show started. None of the information here is considered legal guidance. Speak with an immigration attorney. If you're not one listening to this, this is intended for people in the field, so it gets pretty boring unless you're a great immigration lawyer. Then you're going to love it. Having said that, let's get the show started. Hey, Kevin, thanks again for coming on the show.
Hi, John. Always happy to be here.
So we're going to go over, let's say, last month, September 2023 cases. How's it
That's
looking? Good
right.
stuff, bad stuff, or a mix?
That's right. We're entering into fall. I've got the Halloween stuff already up at the house. With September was ebbing and flowing. It was a pretty heavy month, but but then it got less towards the end, and now the circuits haven't been quite as active in October. So we'll see what I can get you next month. But in September we got some interesting stuff.
Well, it's good. You might have a break in October a little bit so you could have some less reading for once.
It's true, well, when the circuit's only, it's like I can do two, but like if the circuit's only published like one case as occurred last week, that's actually too little for me. Like I need two. So I've got a folder of immigration adjacent cases, one of which I summarized on this last week's episode because it was just this terrible case from the Second Circuit where the woman had been sexually assaulted by an ICE officer and she was bringing claims under the Federal Tort Claims Act, and they said her claims were untimely, all this stuff. But you know, you can listen on the Immigration Review podcast if you want that. But I guess sometimes I can't just do one case. I got to do at least two. Is what it turns out.
Well, a quick note on that. I'm not sure if it's the same case, but we interviewed an attorney who was representing a woman who caught an ICE officer who was abusing a position for sexual favors. Actually, I haven't interviewed him like 3 weeks ago, and I saw him posted it. I think that's no. I posted him? I think I interviewed him, but it's a crazy story. I think I did it. I gotta find it. But Billy Husher, episode number 277. In March, I interviewed him, so it probably was a month before that interview. So it's probably maybe the same case, but hopefully it's not if they lost out
Yeah,
because of statute of limitations.
I don't think it was because the Second Circuit had George Kramer as the attorney. So
Okay.
maybe there's more than one ICE officer out there committing sexual assault, which would just, of
That's
course,
hoping
be
it wasn't the
terrible.
case. I was
Yeah.
hoping it's just this one, but
Yeah.
that's where we're living.
Well, putting that aside, interesting stuff in September. USA v. Minter is the first one that I've got. And it was not even an immigration case. It's out of the Second Circuit from September 6th, but it's sentence enhancement and on the concept of a serious drug offense.
Hmm.
And the federal public defender argued that the sentence shouldn't be enhanced for Mr. Minter, by the way, like by 15 years.
Yeah.
Because his prior conviction for, I want to say, was dealing cocaine wasn't a serious drug offense because the definition of New York cocaine includes more cocaine isomers than does the federal definition of cocaine. It's budding argument that's being the seventh, the eighth, the 11th to a degree. I want to say that might be it. About the concept that a drug itself can be internally overbroad, can cover more substances than the federal same drug,
Hmm.
same name, but composed of different things. And in USA v. Minter, the Second Circuit said yes. New York criminalizes more cocaine isomers, even if they never actually convict or bring the charge, even if we don't even know what they are. New York criminalizes more isomers than does the Fed, which means that New York's definition of cocaine is broader than a serious drug offense. It's not divisible. That to me means New York cocaine is out. It's done. No removability for New York cocaine, in my opinion, based on USA v. Minter. It's huge. It's huge. It's a huge thing to hold these circuits. And with New York, I mean, there's just so many people in New York, so many immigrants in New York. I can only imagine that there are more New York cocaine convictions than there are other types of states' cocaine convictions. And the Second Circuit, to me, just threw it out the window.
I
Can't be
think
a controlled substance offense anymore.
only I guess Florida would have more convictions than this, but
Florida came close with the Shamu decision, I want to say last year. And I think Florida would buy the 11th Circuit would buy the argument, but the 11th Circuit said they weren't convinced that the isomer existed in the world. But if you could convince them, then it seems that they would adopt the argument.
Mhm.
That's a complicated, quite frankly, I think the 11th Circuit just didn't like the idea. And they had a great expert report in Shamu, but they did outline what needs to happen for next term, to be honest with you. Like it could happen in the 11th, but it's huge. And here's the reason. Here's the argument. There are two types of isomers: stereoisomers and constitutional isomers. Whatever they
Are
say
you
what
making these
they are.
names up or what?
Right now, that's well. If you want to know, stereoisomer is an isomer in which the atoms are joined in the same order but in a different. Is all other isomers, including positional isomers. It
Okay, so
means nothing. It's gibberish. But the controlled substance isomers, if a state includes constitutional isomers in their definition of cocaine, or probably meth, to be honest with you, because I think meth is also made out of isomers, then it's overbroad. Said the Second Circuit, and the Eighth Circuit and the Seventh Circuit have said similar things, but a bit more narrow. This one is huge. New York cocaine is out to me. It's huge.
get your motions to reopen out or what?
Well, that's whether absolutely yes, absolutely. Whether or not there has been a change in law such that you can make your untimely motion to reopen untimely, if it was a fundamental change in law, it's a whole other thing. But
Yeah.
absolutely it's there. And most importantly, going forward. And in your USCIS interviews, preparing your client, even if they have the cocaine conviction, they don't know what isomer they possessed.
Yeah.
They don't know what they possessed. They're not a chemist. And if you've got a chemist as a client, just kidding.
But
It's
they would
crazy.
probably at adjustment they'll probably get a good moral character in some backhanded way, but they could always argue that it was unjust and like it wasn't a proper. Like I didn't even think they would deny a case for one DUI. But this woman contacted me. She had a VAWA case, and they denied her adjustment because between the VAWA filing and the interview, which was like 4 or 5 years, she had a DUI, and they said, okay, bad moral character. They denied. They didn't give opportunity to challenge it or provide
Right.
evidence. So there's an appealable, really easy appealable thing on that. But I didn't even think they would deny it based on one DUI because I've had one DUI cases and they had issues. So yeah, these officers sometimes go hardcore.
Yeah, no, but by no means. But my focus is always how do you prevent removability?
Yeah.
And it's a big deal. USA v. Minter.
It's,
Because
that's yeah.
I doubt New York is. I'm sure New York has always had this overbroad isomer thing. It's probably forever. Probably all to do your research. So big case.
Well, thank you for that. It's very interesting. So it could affect a lot of people's lives. What do we got next?
Two from the BIA. Talk about the BIA when they give me cause to on your podcast on your podcast, John. First is matter of CGT, which is about the 1 year deadline for asylum and gay men in the Dominican Republic and reporting harm to police. And asylum claims are always very fact specific, but I like this case for a variety of reasons, but including just off the bat, where they're kind of putting a period on sexual orientation claims. In this world, the world ebbs and flows, the country ebbs and flows. You've got the gay marriage cases at the Supreme Court. It certainly seems like the pendulum swinging in America to supporting same-sex couples, same-sex acts, all of that. I know I certainly do. But, in recent years, you've seen maybe the pendulum swing back the other way. And to me, it seems the BIA is intentionally putting its thumb on the side of where it lands. And here's the quote. They didn't have to say it. There's really no reason for them to say this quote, but they did. Quote, like other protected grounds, is a characteristic that is either beyond the power of an individual to change or is so fundamental to individual identity or conscience that it ought not to be required to change. End quote. The BIA is also saying in this case that to the extent that the immigration judge implied, and it seemed like the IJ might have, although it was unclear, that Mr. CGT could have avoided harm in the Dominican simply by not engaging in same-sex conduct or not, I don't know, being openly gay. I don't
Dating.
even really know what that means. But anyway, the BIA is saying that was error, being very clear that people don't have to, I guess the term is be in the closet to avoid harm in their country. So that's very good to see as well by the BIA.
You shouldn't have to say that because it's like if you're a part of religion, you can't be forced to not practice your religion just so you keep quiet and don't offend the authorities. It's kind of peculiar.
Well, and that's exactly what the BIA is
Yeah.
saying, and that's why it's kind of obvious. But you know,
I thought you were going to
one
go
thing
the other way on
look at
this
it.
because when you started this, I thought the BI was going to say like, yeah, you should be able to stay in closet. I'm almost like, damn it, no one said that. I thought you were
No,
going the
no,
other direction.
if that's what the BIA had said, I don't think I wouldn't have certainly wouldn't have identified it for your podcast, John. Absolutely not. No, the BIA is being very clear. You don't. That's exactly their point. It's just like any other protected ground.
Yeah.
And so it's great to see. Another great thing is a lot of the harm to Mr. CGT in the Dominican happened when he was a child. And the BI is saying very clearly, kids aren't expected to report harm to law enforcement, especially when it's sexual abuse.
Mhm.
Like like an adult might be for asylum purposes. And oh, by the way, a failure to report harm is not necessarily fatal to an asylum claim. The unable or unwilling got you got 11 circuits adjudicating asylum decisions plus the BIA, and depending on the panel, and sometimes they're applying this requirement of reporting harm for past persecution harder or not as hard. And here's the BIA saying it's not fatal. That's not the law. Your case is not necessarily tanked just because you didn't report it, if at a minimum you can show that it's futile or would have been dangerous to do so. And when police are corrupt, maybe that's the case.
Well, very good stuff. We got some good. I mean that one's you take that to the bank, you use it in your emotions and stuff. So that's good.
That's right. That's right. The not so good one, though, from the BIA that I have to talk about is a matter of Cabrera Fernandez. I mean, there's not much to talk about because the BIA dismissed up to the circuit.
Really quick,
And
I'm really sorry, cut out on my end, but you said this BI is not really good, and from there,
oh yeah, no. But the next one that's is not so good is matter of Cabrera Fernandez. This is the Cuban parole case.
okay, yeah. Oh, I saw all of a sudden people were emailing and everything lit up on the Facebook groups, and
Oh
they're like, "What's
yeah.
going on with this one?"
Hey, we've been waiting for this decision for like 3 years. 3.5 years, seeing maybe some politicking at the BIA, deciding what to do, not so much how to do it.
Yeah.
Um, but it seems to me that this is just the BIA saying, look, we know this is going to the circuits, so here's what we think. But the BIA in this decision, they took a case where certain issues I think were conceded. For example, in this case, I do believe that the non-citizen's attorney conceded that the individual was paroled into the United States. I think that was conceded, but that is not conceded in a lot of cases. The whole argument is that every time you release a non-citizen, you're doing it pursuant to humanitarian parole under INA Section 212 D5A. And if that is true, then it's a parole that's based on the Jennings versus Rodriguez dicta, in Jennings, the Supreme Court says everybody who comes to the border is subject to expedited removal. If they're detained, they're subjected to expedited removal, and they're not entitled to a bond hearing. And the only way to release them is 212D5. That is the logic relied on with Jennings. The BIA doesn't seem to engage with that logic very much. It seems that they picked a case where there is this other issue. And I don't see, reading this decision, how you can really tell whether or not someone has been 212D5 paroled versus 236A2B paroled, unless I suppose the ICE officer writes 212D5.
Hmm.
Much guidance here, would have liked to see more, but I'm sure that there will be more guidance very soon from the 11th Circuit, most likely, because that is where a lot of these cases are originating, but not all of them. There have been some of the 5th and the 9th and probably everywhere, and so we'll see who's there to take it to the petition for review.
Yeah, this is an issue that pops up all over the place the last many years. So it always confused me the difference between these two paroles, the D5 parole versus the other version. I was like, what's going on? And at least this situation gave me more clarity on finding the research for it to like what these things mean.
Yeah, well, I mean, that's the whole thing. I think it was a given for a long time that being released from detention was not a parole in the sense of that it's a parole. It was more of the 236 A2B, just go
Mhm.
forth
Yeah.
type thing. But Jennings v. Rodriguez, Supreme Court dicta or whatever you want to call it. I mean, Supreme Court opining, strong stuff. It's the Supreme Court.
Mhm. Definitely.
Um, and it seems like they're saying that there's only one way to do it. And also, ICE has unlimited authority to parole people in for humanitarian purposes. Um, seems like a good argument. Could have been a much bigger decision.
Yeah.
But of course, that would have then set up the BIA to being attacked in its decision once it inevitably goes to the circuit. So we'll see.
Good stuff. Well, thanks for sharing that information. It's always interesting, and these couple of cases you said are actually interesting because there was stuff I was researching and trying to figure out for the last couple of years, and I kind of put it all together.
Yeah.
How does this October look for you? We got Halloween coming up, but before then, a lot of traveling, or are you gonna be in town?
No, I mean, in town and traveling. I think I've got a naturalization interview to go to. It looks like I haven't received the notice yet, but I've seen, I've received the ominous USCIS online thing that says, we have sent out a notice
Yeah.
showing that it's been set for interview. Like, just put the interview in the email, bro.
Yeah.
But waiting for that, and there, I mean, we just filed this too. I mean, I guess they're setting naturalization interviews up really quick. Probably do that. There's Ayla, California's in San Francisco. I'll be there if you're there.
No, not
You
going to
gonna
San Francisco. No, between the kids and not wanting to go to San Francisco, frankly. I'm like, plus San Diego, I found a way
go?
there. No Cal, I'm a SoCal person.
But between the kids and not wanting to go to San Francisco, it seems like that's the more important one. Not wanting to set foot in the city.
No, I remember I went to Ayla National there and all this stuff. I'm like, I'm never coming back here until they fix this place. It was like a mess, and that was like 5 or 6 years ago or whatever. I was like, I'm not really into coming here anymore.
I like San Francisco.
It was a cool
I will
city,
defend
but
San
it
Francisco.
was crazy. This was before as bad as it is now. I was walking around like this looks like we're in like a I don't want to say some country's name, but it looks like a pretty third world.
There are a few streets that are have a lot of homeless people, but like
It's
you don't
right where the
actually.
conference was, and actually, the owners of that building or whoever leased it or whatever, they failed to make the note payment. So that the buildings where the Ale conference, these two sister buildings that are a Hotel Hyatt or something like that, they actually are going under because they stopped making payments on the note on it. Right? I was like, oh, I know that building. That's where the conference was. So it's I mean, enough bashes here in Francisco, but a little tidbit there. What I want to say is, yeah, so I had a Nats case in San Fernando Valley. It took 2.5 months. Then again, I got other ones that are taking longer. But they're trying to get these NAS cases out a lot of times fast, and election years coming up. They usually speed things up during election
Yeah,
years.
yeah. Well, rock and roll.
Yes, have
I'll go
fun.
where they send me.
Well, I appreciate you coming on the show again, Kevin. Immigration Review could be found wherever podcasts are found, and you have a Patreon page too. So
Oh,
definitely support everything you can because there's a lot of work you're doing. This is extra, what's called extra time or overtime kind of work that you're doing. But much appreciated, Kevin. Thanks again.
thanks, John. You too. And I'm going to get to reading a Seventh Circuit decision that got published today. Maybe I'll talk about it next month.
For sure. Look forward to it. Thanks, bro. Have a good one.
Bye, you too.
Have you ever felt that the road to establishing a successful immigration law firm is riddled with unexpected obstacles and setbacks? I've been there, and I'm here to tell you, you are not alone. Picture this. My wife, then girlfriend, and I had just landed for a vacation, only to be greeted by a voicemail that changed everything. In an instant, once the plane landed, she lost her job. The very one job that was supposed to support us while I launched my own solo immigration law firm. Suddenly, our financial cushion vanished, and I was thrust into the high stakes world of entrepreneurship with no safety net. Despite a slow start and a discouraging lack of leads and referrals, I remained determined to build a law firm that provided a 5-star client experience. After countless hours spent researching, watching, and implementing marketing strategies with mixed results, I eventually began to see my firm's revenues not only surpass my previous revenue and salary as an associate, but double it. Today, I run a successful law firm with a team of associates and support staff, and I'm the proud founder of the Immigration Lawyers Toolbox magazine, podcasts, courses, workshops, and more. But my journey wasn't easy. I made many mistakes, wasted time and money, and wished I had a mentor to guide me through the challenges. Although I was fortunate enough to find a few peers who offered support, I couldn't shake the feeling that there had to be a better way. That's why I decided to be the change I wish I'd seen. This month, I'm thrilled to announce the launch of the Immigration Lawyers Toolbox private mentorship and peer group. This exclusive group is designed to bring solo and small firm practitioners in a monthly, private, and intimate setting to openly discuss business strategies, share successes, even exchange invaluable tactics that they wouldn't share anywhere else. By joining this premium group, you'll not only benefit from my hard-earned expertise, but also forging long-lasting relationships with like-minded professionals who are committed to elevating their practices. Space is limited for this game-changing opportunity. If you're ready to make a real, lasting impact on your business, simply email me at info@immigrationlawyerstoolbox.com. Again, that's info@immigrationlawyerstoolbox.com. And I'll send you all the information you need to get started. Don't miss this chance to transform your immigration law firm and reach new heights of success.